So now my question is, I'm not rich. I've saved enough. I'm in my early 30s, fairly healthy, touch wood. Do you think I should write a will?
We once had someone, Hindu male, passed away with mother, wife and children. So the question is, who will apply for the letters of administration? For 6 months they could not decide whether the mother should apply, whether the wife should apply, because there was a complete lack of trust.
If I have to write a will right now in front of you, then how do I go about? So what should I write here?
There is a concept called a letter of wishes. So you can give them a letter of wishes saying, look, I am appointing you as guardian for my child. My wish is that you do this XYZ. So you can also say that my wish is that my child studies in so-and-so school or goes to such and such college. Please use this income for them in XYZ way.
Now a lot of Indians are having exposure to US stocks, right?
Correct.
You know, how to persuade parents also to write a will without making them feel offended? Shaishavi, thank you so much for joining us today. Listeners, let me introduce Shaishavi to you. She is a lawyer, not just any lawyer, a lawyer and a ranked solicitor. She's with Cyril Amarchand Mangaldas, one of the leading law firms in India. Her experience includes succession planning and estate planning. Correct me if I'm wrong, Shaishavi. Let me break it down to you, listeners. I think she deals with rich families and helping them how to distribute their wealth, assets and businesses to the next generation. Is that right?
That's absolutely correct, Satya. Thank you.
Done. So I asked Shaishavi because of the rich experience that she had with wills, trusts and various things that involve succession planning. I asked Shaishavi if she could help me write a will for myself. And she graciously agreed to spend some time this weekend to answer all my questions about will and the process to follow. So thank you so much, Shaishavi.
Thank you, Satya, and thank you for giving me this opportunity to help you write your will.
Thank you so much. So let me just tell you my profile. I'm in my early 30s and say I'm married and I have a minor child. I've been investing for the past 5 to 6 years, invested in a few stocks, mutual funds. Because I'm a salaried, I get EPF, Employee Provident Fund, and I have few fixed deposits. Say, with my spouse jointly, I also bought a house property. It's in the joint name and we are repaying the loan.
Got it.
Now my question is, by the way, since I am with Zerodha Varsity, I also know the importance of insurance. So I have my both life insurance and health insurance. So now my question is, I'm not rich. I've saved enough. And I'm in my early 30s, fairly healthy, touch wood. I've nominated my family for most of my financial holdings. Do you think I should write a will?
So Satya, yours is, a typical sort of Indian middle class person like all of us asking the same question.
Yeah.
Saying, I am not very wealthy. I have some assets. Do I need to write a will? And why should I write a will? What happens if I don't write a will? And I think the answer to all of these questions, very simply in one word, is yes, you should write a will. It becomes easier for your family to go and have access to those assets from banks, etc. All they need to do is produce that will and say, please give us access. In your will, you can name a guardian for your child should something happen to you or your husband. And this is something that many people don't know, so they don't do it. Because if you don't appoint that guardian, then that child doesn't have somebody who can look after them. And your family members will then have to go to a court to get a guardian appointed. And so let's understand what a nominee is. The facility of nomination that the government has given is actually to help banks and other institutions where you will have a nominee, right? So you might have a nomination for, like you said, your bank accounts, demat accounts, etc. The nominee goes to those banks and demat depository participants and says, look, I'm the nominee, you give me these assets. The bank and depositories and EPF and everybody will give those assets to the nominee. This facility is actually to help the banks and the other institutions so that they don't have to sit and worry about who the heirs of the person who has died are. So they will just simply say, you are a nominee, please take these assets.
Okay.
But the nominee doesn't become the owner. The nominee is akin to a trustee, And so that person has to hold these assets for the persons who are the actual heirs. So in your example, if your husband is a nominee, if you appointed your husband as a nominee, he can collect these assets and the money, but it doesn't belong to him. It will still belong to him and your child in equal proportion, because both of them will be your heirs. Whereas if you write a will, you can ensure that everything goes to him as per what you want.
Got it.
And can I just say this? This is sort of, we're talking about you, but if we were to take your husband in this case. Your husband's heirs, if he doesn't write a will be his mother, you, and your child. The estate gets divided amongst 3 people. And this is where we have seen a lot of disputes, where young Hindu men have passed away without writing a will. And then, because the mother, the wife, and the child are all entitled to 1/3, there is a dispute. And very often the mother and the wife then cannot agree on various things, how to proceed. And it is definitely an avoidable situation. And in this case, say the wife is the nominee, the mother will feel bad. If the mother is the nominee, she may not give money to that wife, although all of them are entitled to it. A will helps save all of these problems.
Okay. And people don't usually understand that there is a difference between nominee and will. And if it's just a nominee for a bank account or a fixed deposit, then, the family member might think that, since I am a nominee of this particular fixed deposit, the entire money should be received by that particular person.
That's a very common misconception that occurs, because people assume that the nominee is the owner, but that's actually not the case. And so I think it's also important to realize that it is very important to have nominations in place for all of your assets. So you've done actually a wonderful thing, you've been proactive and had nominations. I would definitely suggest that everyone should appoint nominees for all of their assets where that facility is available. But don't rely on those nominations to get the assets to the persons that you want to. Write a will as well, and ensure that whoever you're writing in the will as the owner of those assets is also the nominee, to avoid any confusion.
Okay, that's again one more thing that I want to ask more questions on. So there is no right age for writing a will. One can write the will anytime.
That's absolutely correct. One can write a will anytime after one is 18 years of age. So basically, once you are a major, you can write a will.
Got it.
And it depends on what your assets are. If you're already earning money, then write it at 18.
Got it. Makes sense. Now, if I have to ask you, Shaishavi, on if I have to write a will right now in front of you, then how do I go about? So what should I write here?
Yeah. So the first thing, Satya, that we start with is, of course, your name, age, and your residence.
Yeah.
This is to identify who you are.
Yeah.
Then we will also write what your religion is. The reason religion is relevant is because different religions in India have different rules. And especially, this is not relevant for you, but for Muslims, they can give only a certain percentage of their estate under their will, which is 1/3. So they can't write a will for their entire estate. So you need to write your religion to be able to say that I am Hindu, I can make a will for my entire estate.
Okay. Got it. So name, age, residence, religion. So these are the basic details.
This is the basic detail. So that's what we will start with.
Yeah.
The next sentence will be to say, if you have already written a will, then we will add a sentence saying, whatever my previous wills are, I'm cancelling them. And this is very important, because sometimes there's confusion if there are 2 wills, saying which is the relevant one. So
the updated one will be the relevant one, no?
There is some confusion on this as well, and the Supreme Court judgments on this aren't always specific. So for instance, you may have made one will and refer to some assets there, and then you make another will later where you refer to other assets. And so the confusion is, did you intend to have 2 different wills for different assets? So best to avoid all of that confusion and write a sentence saying this will cancels or revokes my earlier will dated so and so.
Got it. Yeah.
Right, so that's how we started.
Yeah.
The next sentence that we typically write is to say that I'm confirming that I am of sound mind and I know what I am doing. Why is this important? Is because the law says that you have to be of sound mind when you're writing a will.
Okay.
Which essentially, in very simple words, means that you need to know what you are doing. And so you'll write there saying, look, I know what I'm doing and I know what impact this will has on me and my family and my assets.
Got it.
So that is typically a sentence saying, I confirm that I am of sound mind and I am making this will out of my own volition and nobody is forcing me to do this.
Yeah.
Right? So that's how you start off. Then there are 3 components that are relevant for your will.
Okay.
The first is to identify who you want to give your assets to.
Okay.
And so here let's be slightly technical, okay? So you who are making the will are called a testator.
Okay.
The people who you want to give your assets to are called beneficiaries or legatees.
Okay.
Right? And then there's a third class of people who are called executors, who will give effect to whatever you have written in your will.
So they will enforce whatever I have written in the will.
Absolutely. They will enforce whatever you've written in the will.
Got
so
it.
These are our 3 main actors in a will.
Okay.
Now, when you write your will, in this clause that we are on, you will say that I have so and so assets and I want to give them to so and so after I die.
Okay. So, by the way, as you said, the beneficiaries and the executor, should they be around when I'm writing this will?
No. You can have them around, but you don't need to have them around. You can pretty much write these in your own living room without having anyone around.
Okay.
What we do suggest is to tell your executor that you've appointed them as executor, because it shouldn't come to them as a surprise at a later date when they weren't prepared for it. And this has happened to us sometimes, when you appoint somebody as an executor, but in their life plans, they want to move abroad to another country. And so they may not want to take up this role. So it's best to talk to them and tell them, look, I am doing this. Are you comfortable? Will you be able to take on this responsibility? And if they say yes, then you go ahead and name them, but they don't need to be around or read the will.
Got it. Understood. Now going ahead with my investments. So since you asked me to list down my investments, so as I said, I have a few stocks, mutual funds, and then house property, on which I'm still repaying the loan. So should I go about listing all my assets and say that each asset goes to so and so person, or can I actually say all my assets together, 50% goes to my spouse, 50% goes to my child? Can I do that?
So there are 3 approaches.
Okay.
Like you have noted, one is you list out all of your assets and say this asset goes to this person, this asset goes to this person. That's one approach. The second approach is to say all of my assets will go to X person. So in your case, typically people who are married and have young children will say all of my assets will go to my husband, for instance.
Okay.
And the third option is if you have identified 2-3 people, you can say percentages.
Okay.
My least favorite one is the last one.
Because
it is opening yourself to confusion about what those percentages are. So I'll give you an example. So if you say I'm going to give 50% to my husband, 10% to my son, 10% to charity, 10% to someone else. Parents. Now the question is, what is 50%? Is it 50% in terms of value, or is it 50% in terms of number of items? Typically you would mean value, right? Like if my estate is X amount of money, then 50%. But your husband will say, no, I want the flat. The 50%, I want the flat. Whereas somebody else may say, no, but my 10%, I also want to share 10% of the flat. Somebody else say, no, but I want the jewelry. It becomes very confusing as to what happens. And this especially happens when, say, people who have 2-3 children are making a will. They might say, I'm giving 10%, 10%, 10%. And then there is a huge fight, especially on items like jewelry. Because somebody will say, no, I want that item. But somebody else will say, no, I want that item. So in terms of value, they might be equal. But everybody has a different say on what should be comprised within that 50%.
Got it. So say suppose I'm following the first principle where I'm listing all my assets, which is, asset A, asset B, asset C, asset D, and I'm saying which one has to go to each one in terms of the percentages?
One is we can have some sort of hybrid model as well. So what you can say is that if you have decided then most of the assets go to my husband and some will go to my parents, then you don't have to list out everything. You can say everything goes to my husband except 1, 2, 3, and then list out specifically. So that just becomes easier to do than having to list out 15 different items.
Makes sense.
I'd say I'm giving my entire estate to my husband, other than this jewelry which I have got from my mother, which will go back to her.
Okay.
So that becomes easier.
Cool. This hybrid model sounds good. So now I say all my assets go to my husband and child, and maybe 2 to 3 assets separately will go to my parents.
Yeah.
But what if I outlive my parents?
So your will should cover that scenario.
Okay.
So you can say that I give so and so to my parents.
Okay.
But should I outlive them? Should they die before me? Then this is what will happen to my estate. So what people will say is that, to give an example, that I am giving so and so to my mother.
Okay.
But if she passes away before me, then this will go to my father or my sister. And if neither of them are there, then it will go back to my husband.
Okay. Okay.
And
Makes
so
sense.
it's for every bequest that we do, and that's another technical word. Bequest is basically your noting of what asset you are giving to which legatee. So for every bequest, we suggest you have an alternative as well.
Got it. Got it. When you're talking about the minor child, you also mentioned about the guardian. Could you tell me where I should mention the guardian here?
So in your will, once you have named all your beneficiaries, then we will have a clause on executors, which we will come to, and then you can end it by speaking about guardians.
Okay.
So you have a clause on guardians, and it's very simple. All it needs to say is, should something happen to my husband and me, then we have a minor child, and so person will become the guardian for my minor child.
Okay.
If you want to give any instructions, of course, you can give it to the guardian saying, please look after my child, please ensure that X amount of money is used for their education, etc. But at the end of the will, that's all you need to do. And again, it is suggested that you have an alternative as well, because you might appoint someone, but that person may not be available. You may outlive them, etc. So just appoint an alternative as well.
So can the same executor be the guardian for my child as well?
Yes, absolutely.
Okay.
You can have the same. If this is someone you trust, you can name them both as executor and guardian.
Got it. Got it. So can I mention that the guardian should use the income from an asset, or by selling an asset, or from the income from such an asset, should be used only for education and nothing else?
You could do that, but I wouldn't suggest you do that, because you are taking away their ability to use the money and income for any other contingency. For instance, if there is a medical requirement, then if you say only for education, then they may not be able to pay for that medicine, or God forbid, any hospitalization or general lifestyle expenses. If your child needs something, needs to be flight ticket needs to be paid for, then by having rules that are so rigid, we're taking away their ability to use that income for your child.
Okay. So who will mentor the guardian?
So ideally, you should choose someone who you feel comfortable that this person understands you, your child, your lifestyle, and will be able to take care. You can always give them guidance. So you can write a letter to them, or you can write it in the will itself, or there is a concept called a letter of wishes. So you can give them a letter of wishes saying, look, I am appointing you as guardian for my child. My wish is that you do this XYZ. So you can also say that my wish is that my child studies in so and so school or goes to such and such college. Please use this income for them in XYZ way.
But this is just a wish.
This is just a wish. It is not binding on them. It is your guidance to them saying, this is what I want you to do. And you have to give them the flexibility of making that choice, saying, no, in case this child needs this money for some other reason, I will use it for them. And this is based on trust, to be honest. If they do something that is against the law, then they're answerable to a court. But the best thing is to appoint someone that you truly trust will look after your child. and somebody hopefully that your child is also comfortable with.
Understood. Got it. Now, yes, I've mentioned my beneficiaries. I've mentioned the percentages that they receive. I mentioned about the guardian who actually will be for my minor child in case unfortunate passing away of a spouse and me as well. Now, what's the next process?
Yes, then we appoint your executors.
Okay, I mentioned here the executor.
Yes, you mentioned the executor.
Okay.
And like we've discussed, the executor is someone who gives effect to whatever instructions you have given in the will.
So this person will make sure that if, say, suppose if my mutual funds have to be distributed between my child and charity, so this executor will make sure that mutual funds are actually being utilized only for my child and charity.
So they will do a few things. One is they will collect if you have given money to someone or your money is in bank accounts, etc. They will have to first collect your assets.
Okay.
Then they distribute it as per whatever guidance you have given in your will.
Okay.
If you've given any instructions on payment of money to anybody like loans, liabilities, they will also do that. You can also give them instructions if you sometimes people have fancy requests on how they want their funerals to be, saying organize it this way and get so and so to sing at my funeral. So you can give those instructions as well and say that whatever money you spent on this, you will be reimbursed from my estate. So you can give all of these instructions and they will give effect to those.
The assets will never go in their name. Correct. It's just their facilitators in between.
Absolutely. They're facilitators. They almost like a trusteeship role, like we were saying for nominees, that the money is not theirs. They just have to give effect to the guidance you have given in your will.
Understood. Going back to my question on naming the assets, there are two questions here in terms of the property. So the property which I have now, on which I'm still repaying the loan, can I still include that?
Yes, you can. You can include that, and you should do two things. One is that, or at least you should consider two things. One is because you've bought this as a joint asset with your husband, it makes sense to say that whatever my interest in this joint property is, it'll go to my husband.
Okay.
Because if you give it to someone else, then your husband will have to deal with some other person in this. So it makes sense to give the asset back to the joint holder. And the second thing is you can give instructions on how that loan has to be paid off.
Okay.
So what some people will say is that, look, I have this money that you get from this bank account. Use this, like I have set aside some money for this loan. So you please use this money to pay off that loan.
Got it. The second question in terms of the house property is, say suppose I might receive a house property in my name from my parents.
Yes.
Which I haven't yet.
Right.
So can I include such future assets also in this will?
Absolutely. You can do. The will is supposed to operate from the date of when you die. So all of the assets that you receive, either you buy them, you inherit them, you may be gifted those assets, all of those will be covered in your will. So if you're anticipating that somebody is going to leave if you have a rich aunt, please tell me. So if you're anticipating that someone's going to leave you any assets, you can say that I am expecting to receive this and this is how I want it to go.
Understood. So yes, listing is done, guardianship is done, executor, naming the executor is done. So what's the next step?
And so can we come to naming the executor? I think there are some things that we should bear in mind.
Okay.
One is, a common question is how many executors should I name? So you can name one, you can name two, depends. It's normally one or two is the one, but always have an alternative. So I think this is something that we've always discussed. Even when we were discussing bequests, we said have an alternative.
Yeah.
Because the person you name as executor may not outlive you, or may go off to live in another country, may not be available, or for whatever reason may have some physical handicap and they may not want to take this role on. So have another person, have an alternative saying if so and so can't act,
got it,
then Y will act. You can, like I said, give them some instructions as well.
Yeah.
There are some people who might want to give some remuneration to their executors for acting. So if you have a family member, typically people don't do that. But if you're, say, appointing your CA or someone, you might want to pay them from this.
Okay.
And another clause that is important for executors is that if you are appointing an executor who is also a beneficiary, who's taking some bequest under the will,
Okay.
then you want to clarify that, look, I am giving this bequest to them out of love and affection, not because they are acting as executor. Because the law presumes that if you are appointing an executor and giving them some asset, it is because you want to compensate them for taking the effort to become the executor. So you just have a sentence saying, whatever bequest I have given to my executor.
Why can't I actually give from the same wealth that I have to the executor?
Absolutely, you can do that. It's just that you want to clarify that I've given it out of love and affection or whatever, and they will get this bequest even if they don't act as executor. Like if for whatever reason they can't act, then you don't want them to lose that. So you want to say that these two are independent.
Got it. Understood. So yeah, once this is all done, should I read out all this to my beneficiaries?
You could, but you don't have to. It's really not required for your beneficiaries to know what you have said in your will.
Okay.
You could do it if you wanted to, right? If you're a small family, your husband, you'll tell your husband that, look, I've made a will, and at this point I want to give. But it's really not compulsory. And the reason is you might want to change your will. You can change your will every single day. So today you might have named somebody or given a certain percentage, but tomorrow you might change your mind. So if you tell your beneficiary today and you might change your mind later, then that becomes a little awkward.
Got it. So what's the next step?
The next step is that once you've got this, you've written out all of your instructions, you just need to print it.
Okay.
White paper is fine.
Okay.
Sign it so that we'll have a signature clause at the bottom.
Yeah.
And you need 2 witnesses.
Okay.
To witness you sign the will, they have to be around, they need to see you sign the will, and then they will sign in front of you saying, I am the witness and I have seen this happen in front of me.
Got it. And this witness can be anyone?
This witness can be anyone technically, but let's just think of some of the things we need to keep in mind. For Hindus, the witness can be the same as the beneficiary. So in your case, if you're making your husband the beneficiary, he can also be the witness, no problem. And when I say Hindus, the law of Hindus applies to Jains, Sikhs and Buddhists as well. But say if you were Christian, then that doesn't apply. So for Christians or Parsis, we will always say, have a different person. Don't make the beneficiary also a witness. Now, why is a witness important? Is that tomorrow if a probate is required or there is any question on whether you actually signed the will, they will confirm that yes, I saw Satya sign the will and I confirm I was a witness and this is actually her will and she was absolutely fine when I saw her do that. The mistake that people make is they will pick up somebody random and say, you just see me witness my will. Problem is that later you might not find them when somebody wants to rely on your will. So for instance, you have your office peon and you say, please witness kar lo. But tomorrow you leave your job, 10 years later, nobody's going to be able to find that office peon to be able to confirm that you actually signed the will. So ideally, this should be someone you know and have ready access to.
Got it. And they should also sign and mention the date.
You have to mention the date. They have to sign and they have to write their name and address next to it. The only reason is that is to identify, because there are very common names. So who is that person? Like a Rahul Kumar, there might be many. So just you write your address so that you identify who that person is.
Got it. Now writing the will is done. So what should I do next to give effect to this paper? Should I get it registered or it should be notarized?
No. So the 3 questions that people sort of always grapple with is, do I need to put stamp paper?
Yeah.
No, you don't need to put stamp paper. A will doesn't require stamp paper. The second question is notarization. You don't need to notarize it. The law doesn't require a will to be notarized.
Okay.
The third question is registration. The law doesn't require a will to be registered. So you don't have to register it. There is one benefit to registration, which is to confirm that if you are saying you've written the will, that means that you have actually written it. So it is proof. And this is what happens when sometimes, there is a forgery. Like someone is writing, we've seen this in the movies and all, where somebody is writing a will for someone else and signing for someone else. You avoid this when you register the will because you sign in front of the registrar. So it is proof that it is actually your will. Registration is also sometimes, we suggest it when there are older people, when there are questions on whether they knew what they were doing. Like somebody, sometimes is a grandparent, very old, maybe early stages of dementia or something. So those kinds of people where there might be a risk to validity, we say please do register. The other thing that you don't need, but someone who is slightly older may want to consider, is having a doctor's certificate. Because you're young and all of that, but say if your grandparent were making a will and they were fairly old, we would say keep a doctor's certificate of the same day where the doctor has examined you and confirmed that you are of sound mind and body, and there is no question that you knew that you were making this will and what you were writing in it.
Got it. Understood. Now, say I want to be extra cautious and I got the registration done of my will. Now, where do I store this? I mean, usually what do people do?
So if you want to be extra cautious, the other thing you can do actually is videotape the signing of the will. So if there is going to be a question, some of our clients, for instance, anticipate that tomorrow somebody might question their will, or might question saying, did you really sign the will? Was somebody influencing you when you were signing the will? Was a son, child saying, please sign? So in these cases, we say you videotape the will. You videotape the signing of the will, the executor sitting there, and ideally also read out the will. So you can prove that, look, I knew what I was signing, and these are my instructions. And then once you videotape it, keep that recording safely somewhere for future use. So that is if anybody wants to be abundantly cautioned.
Got it. Yeah, coming back to my question, because now we are living in a digital world, where do I save this physical copy? Bank locker?
We don't recommend bank locker, and I'll tell you this, one of my clients had a really bad experience.
Okay.
Father left a will in the bank locker, did not have a nominee for the bank locker. The key for the bank locker was lost. Family didn't know they weren't sure that the will was in the bank locker. They presumed that, okay, it must be there. So we had to go to the High Court. We had to get an order. High Court gave an order to Godrej, the ones who make that bank locker for the banks. The Godrej people had to come. We had to be there in the presence of a High Court officer, get it opened up, get the will from there, and then have to pay for that Godrej locker, which was now damaged, to be replaced. So do you really want that? It could sometimes lead to these very unexpected issues. So keep it safely. If you have a sort of locker at home or a safe at home, you could keep it there. Keep it somewhere where you can have access to it readily, but not
and I have
everyone.
to let them know that, my executor at least.
Exactly.
That my will is placed so and so.
Correct. So you have to let your executor know where your will is. What sometimes people do is they keep 2 copies of the will. They'll keep one in one place and another in another place. Tell your executor you're doing that as well, because otherwise it could lead to confusion saying, why are there 2 copies of the will?
Yeah.
So let them know where you've done it. Where we want to sort of be very careful of this, we will ask the testator to write a letter to the executor saying, please note, I have left it here and here. Sometimes people leave it with their lawyers, law firms, but mention it somewhere so that someone knows where it is.
Got it.
And along with your will, there are maybe 1 or 2 things that you want to keep, right? So if in your will, you may not have named all of your assets like we were saying, right? We could have just said, I'm giving everything to my husband.
Yeah.
It is better to keep some sort of list of assets and liabilities with that will. Because the other problem in India is that nobody knows what assets everyone has or where you have invested. Now it's kind of slightly becoming easier with technology and linking to PAN and all of those things, and regulators are working towards it. But this happens a lot with our clients where the family has absolutely no idea where the deceased person has invested, and it could have been in some random immovable property and the papers won't be there. So just keep everything saying, I have bought this, these are my assets, this is the loan I have taken, and these are the loans I have given. So we've also had incidents where after a person has passed away, people will come at the door of the family saying, so and so owed us so much money, please repay it.
Yeah.
So these things happened in India, and to avoid all of that, put.
Wow, what happens in that case? Say suppose the will is written and it says 100% to be given to my spouse, say suppose. But say suppose I also have liabilities.
Yes.
But I did not mention about my liabilities in my will.
Yeah.
Then what happens if the the creditors come asking for loan? Would my husband be liable to pay that?
So the simple rule is that if it is money that is owed to someone, you owe money to someone.
Yeah.
The person you have given your asset to has to pay it to the extent of the assets they receive. So it is not that your husband will have to pay from his own pocket, but if he is receiving assets from you, he has to utilize those to pay off the creditor. But ideally, even for this, we would want to have written documentation. It should be in your accounts. There might be a loan document to prove that this person is the creditor. And then, of course, the executor and your husband can work together and use those assets. They might have to sell off some assets to pay that, which is why it's always recommended to write in the will saying, please don't sell off this. Please use these investments to pay off someone.
Got it. Even after all this, Shaishavi, you must have seen so many cases. Yeah. What are some of the common disputes that arise even after people have been very organized, written a will, been extra cautious, did everything? What are some of the common disputes that could arise?
So assume the person who has written a will has all of their nominations in place, etc. One of the common ones that happens in India is where they give unequal bequests. So for instance, somebody might have 3 children and might give the bulk of their estate to 2 children and not the third one. The third one will wonder what has happened and is very likely to question this. And here is actually where Indian family dynamics become very interesting, because if there are 3 sons and you give something to 2 sons and not to the third son will ask why. There could be situations where a parent is living with the son and giving 100% to that son and not to some other child. The other child might question. It could be the reverse of it.
But once the will is written, it cannot be questioned, right?
It cannot be questioned, but what the other child will say is that the person, the father or the mother who has written the will, was being manipulated or influenced in some way. That this is not what they would have ordinarily wanted to do. But because, say, they're living with someone, that person has influenced them to take a decision that they would otherwise not have. That's one. They might question whether that person had the mental capacity to do it, saying, no, was very old, was infirm, didn't know what they were doing, and has made this will without, this thing. These things also happen when, say, there was one will made now, saying, I've given everything to everybody equally. And then 2 years later, change that entirely without any context. So people sort of will question saying, what has happened in this interim? So those kinds of situations in India are very common.
And again, it goes to court and everything.
It goes to court. So one of the things we tell people is that if you are making a bequest that is not in the normal course of things, in Indian families, it's common that if you have children, you give something equally. So if you're giving something, you're doing something that is unusual or maybe questioned by someone saying, why, what was the thinking, write it in the will or in another document that you keep along with the will.
The reason is it?
The reason is, so you could, so one of the common ones is to say that I have a child and I have given a lot of assets to this child during marriage, or this person is very well to do, or this person is living in another country, but this other child, needs my money, or I am living, they're taking care of me and spending a lot of money for me. Therefore, I am giving more to this child and not so much to the other child. So if you're able to explain that, then it mitigates to some extent the ability of someone to question what you were thinking.
Got it. Makes sense. Now everything is done. I think the storage is also good. But as you said, I can also keep changing this will whenever I have newer assets or maybe newer liabilities. I can keep, or my interests itself change. So I can keep updating this will.
Absolutely. So a will is very easy to update. You can do that frequently. There are 2 things you can do. Either if you want to make minor changes to your will, you can execute an amendment, and the technical word for it is codicil.
Okay.
Codicil is signed in the same way as a will.
Okay.
You can print it out, white paper, you sign it and 2 witnesses sign it, and those 2 witnesses don't have to be the same one as a will.
Okay.
It's better if they're the same because it's easier that way, but they don't have to be. So that's option 1. If you're going to make significant changes, then just write a new will and cancel the earlier one. And not only cancel, you can actually just tear the earlier one as well so that it doesn't exist.
Okay.
And what we also actually recommend for people to do is to look at their will every year or every few years, because life changes, life events happen. You might have another child, and you want to just relook at it. There might be births in the family, there might be deaths in the family, there might be you might acquire some big properties, so to cover all of those situations.
Got it, understood. By the way, this is a very, very stupid question, but can it be handwritten or should it be printed?
The law allows both. You can have a handwritten will, you can have a printed will as well. A printed will is slightly better because handwriting, not everybody is, especially if it's a doctor, maybe they should definitely not handwrite it. But printed ones are easier to read. You're unlikely to make spelling mistakes. There are unlikely to be questions on what you have written. So typically we suggest having a printed will.
Got it. By the way, I've also seen some of the online platforms facilitating this writing a will process.
Yeah.
So instead of this process, can I also choose that process? Because maybe that could be more, in terms of legal terms, it could be more appropriate.
For sure. There are many of these will platforms. I personally cannot say whether one is better than the other. So you should do some of your due diligence before you're checking, see the antecedents and who is leading this and whether somebody whoever's founded that knows what they're doing. But those could be very good alternatives to help you formulate your will.
So online wills are also as valid as written wills?
No. So the difference is that you will use an online platform to write that will, but you still have to print it and sign it, what is called, a wetting signature. It can't be a digital signature. You actually have to sign it.
Okay.
And your witnesses have to be present and sign it. So in India, there were questions during COVID saying, should we allow online wills? But that has not been allowed. You cannot have a will online. You cannot digitally sign it. And you cannot have your witnesses, looking at you on Zoom, sign the will. It all has to be in physical.
Okay. So the only purpose of having a online will is to make sure that everything that needs to be covered in a will is covered.
Correct. So you can use those services to generate the will, but you should still print it and sign it.
Print it and sign it. Got it. Now, so far I've asked questions about me writing a will. But there are cases where there are Indian parents who don't think they need to write a will until they are like maybe sick or like very, very old. I think one story that I've heard is that once they've written a will, it's like as if they are giving the control over the assets to the kids. But it is also very, very essential for someone to write a will because of so many reasons that you have mentioned. It's also, as you said, to reduce the conflicts within the family and the word that you used earlier, the legacy. How to persuade parents also to write a will without making them feel offended.
No, you're absolutely right. People do get slightly fearful about when the thought of making a will comes. It also reminds them of their mortality. So I do know someone where we brought up the topic and they fell ill after that because just thinking about their own demise made them emotional and sentimental. So we know that these things happen, and I think it's a normal human sort of sentiment. But I do think it's important to have conversations and explain that a will is really a document that is your duty to your family, because you worked very hard during your lifetime, right? In India, you do all of this, you make your wealth. You will want that after you're gone, that wealth is utilized by your family, is available for your family, and also they remain happy and peaceful after you pass away. A will helps you to do that. It cements a good legacy after you are gone, where people will remember you fondly because you organized. And most people in India, we are sort of, we think about organization. There are many things we organize during our lifetime. So why not use that and organize after your death as well? So I think it's important to explain to parents and family members that, look, this is not, it's really not a sign of anything. It is just one of those things that we need to do to ensure that our family is prosperous after we are gone. And we have seen that when people do this, when husband and wife do it together or people do it together, then they're able to, then they don't feel so isolated, and they say, okay, let's do it. Let's all of us write a will. So like my parents and I, we sat together and we wrote a will, and it's just one of those things saying, yes, we need to do this for ourselves.
Yeah, instead of a individual thing, when it's a group thing, then the emotional burden could be a little lesser.
Correct. So we have seen, there'll be friends who will say that, look, we have to do this for each other, for our children. We owe it to them. We owe it to ourselves to do.
Got it.
So might as well.
So, the whole point of this will is it will make the transmission process easier, right?
Yeah.
Because we've seen so many cases during the COVID also. Many families had to actually go from pillar to post to actually get what they deserve.
Yes.
Especially during the time, so especially when maybe the breadwinner of the family passes away, immediately the family will be in requirement of money. And they wouldn't get the money because documents are not in place.
So I think 3 things are important, for this. One is, like we said, nominations are important, because when you have nominations in place, then the nominee can immediately go to the bank and get that.
What if there is a will but not nominee?
So what happens in that case is then the banks and other authorities will ask for a probate of the will. So you still have to go to court and get a probate, which is why we say that always have 3 things together. Is you have your will, so you're identifying who to, the assets will go to. There is no dispute at all, and you have, sort of pretty much set out what your views are. Supplement that with nominations. So whoever you've written in your will is also then the nominee for that asset, and it then becomes very easy to get those assets. Otherwise, you have to go get a probate or a succession certificate. Again, those are technical terms, but you still have to go to court and get that done. And the third is to consider having at least one joint account. So if your family members, if you are the breadwinner of the family, you have a spouse at home who may not have ready access, you have one joint account which she or he can access if something happens to you, then at least they have that money, in the initial stages.
Got it. One last question in this segment. How is this different from having a power of attorney?
Very different. A power of attorney is a document that you give to someone saying you can take actions for me when I am alive. A power of attorney automatically comes to an end on death. So it is not...
For example?
For instance, I give you a power of attorney. I have a bank account and I am going to America and I can't access that bank account. So I give you a power of attorney saying you please use this, operate my bank account for XYZ reasons. When I come back, then I will cancel that power of attorney. Now, should something happen to me, you can't use that power of attorney and go to the bank and say, oh, Shaishavi gave it to me so I can collect the money. Because when I passed away, that power of attorney came to an end. So in other words, a power of attorney is a document that I am giving to someone saying you can do whatever I can do. But if I have passed away, then I can't access that bank account. So obviously you can't then.
Got it. It's completely for different purposes.
Completely for different purposes, yes.
Got it. Makes sense. By the way, coming back to this will writing thing, whatever you've said so far, yes, you would have considered that I'm a Hindu female, but is it applicable for all Hindu male or whatever religion they're from and all Indians?
So wills for everybody except Muslims, the law is the same. Okay. Muslims have to think about it slightly differently because the Indian Succession Act that applies to everybody else for wills doesn't apply to Muslims. And there is a limit on how much they can give for wills. So that is in terms of religion. Gender, it's all the same. The other nuance there is that some states in India have their own state-specific laws in some of these things. So Uttarakhand, for instance, recently had Uniform Civil Code. Goa has slightly different rules. So one of the things listeners should think about is that ask themselves, which state am I? Am I in one of these? And what is my religion? Apart from these, the rules apply to everybody.
Okay, so only if they're from Uttarakhand and Goa, they have to make sure that
Yeah.
they have to understand what the state laws are talking about the inheritance.
Correct.
Got it. Understood. Yeah. Now, we've talked about will. Now, I want you to tell me there could be cases where people could pass away without writing a will. In that case, which laws will be applicable?
So this is actually very interesting, and India is one of the only countries that has this, is that we don't have one specific uniform law.
Okay.
We have different laws depending on the religion of the person.
Okay.
So Hindus will have something different, Christians have something different, Muslims will have different. And of course, when I say Hindus, again, I use the larger term Hindus, which the law says, so Hindus, Sikhs, Buddhists and Jains are all, there's a separate law. So the first thing is to ask yourself which religion and which law applies to me. And then say if you're Hindu, then it gets even more nuanced, where males and females is different. For Muslims, again, it gets more nuanced because it depends on whether you're Shia or you're Sunni.
Okay, got it. To avoid all confusion, it's better to write a will.
Absolutely.
But if in case, there is no will, let's take a case of Hindu male. How will the assets be distributed? I understand that there will be class 1 heirs and class 2 heirs.
Correct.
Who are they, and how will the assets be distributed?
So for a Hindu male, if there are class 1 heirs, everything goes to class 1 heirs equally. This will be your mother, this will be spouse, this will be children, and children then also includes, if your child has passed away before you, the child of that child. So this is your universe of class 1 heirs. Everybody within this universe
Father will not be part of it.
Father is not. So this is an interesting question. Last week I was at an event and I asked people to show, raise hands as to how many people think father. And a lot of people did think that the father is covered, and they were very surprised to find out that the father is not covered, but the mother is covered. Only if all of these are not there.
This is for Hindu male.
Hindu male.
Okay.
Or only if all of these are not there, then the father comes in as a class 2 heir.
Ah, okay.
Yeah.
Got it. If no one is there, that class 1 heirs are not there, then class 2 heirs come into picture.
Correct.
Which include the father of
and
the
then
Hindu
after
male.
the father will be siblings.
Got it. Makes sense. How is it for Hindu women? You mentioned about it in the beginning of the video, but maybe a little more elaborately.
So Hindu women don't have a concept of class 1, class 2.
Oh.
It is, so that is again something people don't know, because people say who is the class 1 heir for women. But that concept exists in the law only for men. For women, it's divided into 3 buckets. What your assets are, what you have inherited from the family that you've been married into, and what you have inherited from your own parents. And what happens will depend on where that property fits into this. Children typically are covered everywhere, but for other relations, it depends on where you fall within this. Here actually, while we're saying this, here's where another nuance comes in, which is interesting, that these rules may or may not apply to you depending on who you've gotten married to and how. And so let me explain this. If you are a Hindu who has gotten married to a Christian, for instance, and person from another religion, and you got married under the Special Marriage Act before the registrar, you signed before the registrar, then these rules don't apply to you. Then the rules which are the secular ones in the Indian Succession Act, which typically apply to Christians, will apply to you. So that's if you are a Hindu marrying another Hindu under the Special Marriage Act, no problem. If you are a
Hindu laws will be applicable.
Hindu laws will be applicable. If you are a Hindu marrying, say, a Christian or a Parsi under the Special Marriage Act, then Indian Succession Act applies to you. And this is the same with, say, Muslim marrying Christian or Hindu under the Special Marriage Act, then Muslim's law doesn't apply and Indian Succession Act applies. So this is where you have to typically ask yourself, what is my religion? What is my, in some cases, what is my sect? Like say for instance, in Muslims will say, am I Shia, am I Sunni? Amongst these, there are certain communities which are to which Hindu law might apply. So that gets even more complicated. Then you ask yourself, what is my religion, my gender? Did I get married under this law? Did I get married under that law? And that is where you, after, you make it this whole sort of flow chart where you get to finally get to the rules.
Oh, this gets very complicated.
It does get very complicated, which is why our suggestion is that, to most people is please avoid all of this, and any questions on what assets go to whom, and make a will, so you can avoid those disputes, avoid the questions, and have just, for your family, it's great clarity that, okay, everything goes to this one or this one or this one.
Got it. I've also heard about life insurance policies that these laws may not be applicable. Is that right? That the nominee will get whoever I mentioned as a nominee, irrespective of my will, that nominee of that life insurance policy will get all the amount?
So this is actually an interesting question. Some years ago, the Insurance Act was amended, and they changed the provision applicable to nominees, and they said that, the nominee will be sort of beneficially entitled to this. So there are two views. One is that the nominee gets everything, they're not trustee, and the other is that, like every other asset, they're trustee. The reason why insurance is slightly different is because it says that if you are a family member who is a nominee, then you become, you get the proceeds. And that's where some of this confusion is arising. Very recently, a High Court in India said that no, it doesn't matter. Life insurance is the same as every other asset. So the nominee gets as trustee and not as, the actual owner. But in my view, there is another view to be taken. If it is a family member, then the nominee could be regarded as beneficially entitled. And I will confess that at this point, there are two views possible. This matter will have to go to the Supreme Court, and whatever the Supreme Court decides will be the final view. So my recommendation to everybody is that you appoint a nominee, but in your will, you also say that I have this insurance, and the beneficiary of these insurance policies will be whoever I have named as nominee. So you're covering and avoiding any case of
Disputes. Got it. Makes sense. Understood. Say suppose in the will, what if I've forgotten adding a few assets? Or say suppose there are some unclaimed assets in my name.
Correct. So in every will, what we will try and do is cover this situation, because it's not possible to name every asset that you have, or to think of what assets you might get later, either you buy them or inherit them. So we will have what is called a residuary clause. A residuary clause covers everything that you haven't specifically mentioned. So it's very much that the rest and residue of my property, wherever situated, or of whatever kind, goes in XYZ manner. And that is, sort of the ultimate default option, that whatever's not covered gets covered there.
Oh, so I have to go back to my will and add the residuary clause.
Yes, but in your will, interestingly, say if you do it the way we were talking about, saying everything goes to my husband except XYZ, then your residuary clause is that everything goes to my husband. Because effectively you're saying whatever assets I have on my death, whether they're written here or whether I acquire them later, goes to my husband except XYZ. But if you're doing it the other way around, where you're listing assets, saying I give this asset to this person, this asset to this person, then in the end you want to have that clause saying if I've not covered anything above, then it goes to in such a way.
Wonderful. Now let's come to the segment 3, Shaishavi. Even when we were talking during this conversation, you talked about probate a lot. I wanted to wait to understand what is probate till now. Could you tell what a probate is? Because it comes a lot when we talk about will.
Yes. So probate is very simply, the word is to prove a will. A probate is a certificate of the court saying that this will is proven. It is genuine, it is authentic, and it can be relied on. Now, again, as with many other things as we've been discussing, this whether you need a probate for a will or not depends on some factors. So, if you were Hindu, probate is compulsory only in 3 instances, which is if you have written your will in some specific places in India, or if you have immovable property in specific places in India. And so those 3 are Bombay, what the law refers to as Bombay or Mumbai now.
Okay.
Calcutta or Kolkata.
Okay.
Or Chennai. And these are the 3 old British presidency towns. And because this law is, from the British times. They said in these 3 presidency towns, if you sort of are, you write your will, or if you have property in these, then probate is compulsory. In the rest of India, probate is not compulsory.
Okay. Whether it is written in these 3 states or if the assets are lying in these 3 states.
Immovable property, real estate.
Only immovable property?
Yes.
It's not applicable to financial holdings?
No. So that is when a probate becomes compulsory in a sense. In other places, it is not. So if all of your property is in Delhi, for instance, it is not compulsory.
Since I've written my will in Bombay, only one immovable property is there. Should I get the will probated?
So you don't have to. The person who writes the will has to do nothing.
Okay.
After they pass away, the executor is the one who has to go to court saying, please grant probate, please certify that this will is genuine. And that then the court will look at the will. They will get, an affidavit from a witness saying, please confirm that you witnessed the signing of this will. They will look at all of these, evidence before them, and if they're satisfied, they will give probate and confirm that it is a genuine will.
Okay, I have 2 questions here. Say suppose the will that I've written here, it doesn't have a immovable property. It has only financial holdings. Do I still need to get the probate done because it's written in Bombay?
Yes. So again, like I said, you don't have to, but at the time after you pass away, the executor will see whether these tests are met.
Okay.
And they will accordingly then have to get probate done.
Okay, so the financial assets in Bombay, Calcutta, Chennai, or if the will that has any financial assets also written in Bombay, Calcutta.
Yeah, it has to be. So the financial assets don't have to be here. That is not the test. The will has to be written here. So if I'm sitting in Bombay and writing the will here in Mumbai, then I will need it. Or if I have written the will elsewhere, but I have a flat here in Mumbai, then I will have to do that.
Okay. And
so this is what the law says. Now the problem is that in certain other instances also, a probate might have to be obtained. For instance, if there is a financial asset and no nominee has been appointed for it.
Yeah.
So if there is a bank account and no nominee is appointed, then the bank will tell the executor that, sorry, we will release these funds only if you give us a probate to prove that these funds belong to the heirs. And which is why it's kind of important to have nominees everywhere so that we don't need to go down that route. So the bank will either, and I say bank, but it could be any other institution where there's no nominee. The bank can say either get me a probate of a will, or the other word that many people would have heard of is a succession certificate. A succession certificate is similar to a probate in that you have to go to court to get it, but it is available only in 2 instances. One is to collect debts of the person who has died. So that person gave a loan to someone and then money has to be collected, then you can get a succession certificate for that. Or securities. Securities is basically shares, etc. There's a common misconception that you can have a succession certificate for other assets as well. So sometimes people will say that for a bank locker, get a succession certificate, but a succession certificate is not available for that kind of asset.
Only 2 assets.
Yes, debts and securities.
Debts and securities.
Correct.
And securities is only shares, any capital market securities.
Correct. Yeah.
Got it. So one should get succession certificate when there is no will or nomination.
No. So the thing is, if there is no nomination, then the bank will say that you give us some proof that this money is to be given to you. And they will say, get us basically that proof through a court. Now, what is that proof? You can either get them a succession certificate or you can get them a probate. If you are claiming money from the bank, then you can get them a succession certificate and give it.
No, if there is a will, I can go get the probate
itself. You can
get
a probate itself.
But if there is no will, then I can get the succession certificate?
Correct. Absolutely. Yeah. Exactly. So the question that, people may ask is that if I am in a city where I don't need a probate for the will, then can I just get a succession certificate and get that money from the bank? The answer is yes. But say if you had a bank locker, then you can't get a succession certificate. So you have to get the will probated, and you go to the bank saying this is the probated will. Now please release this money, the contents of the locker.
What if there is no will no nomination, they have to then go by the rules of the succession laws.
They have
and the
to, yes.
court will tell how the money has to be distributed, is it?
No, so what happens is that if you have no will, then one of the heirs has to go to court and get something called a letters of administration. So there are 3 applications you can file before court. If there is a will, you do a probate. If there is no will, then a letters of administration. And if you have, will or no will, if you have only debts or securities, you get succession certificate. But essentially, the letters of administration and probate are our 2 main ones. If you have will, probate. If you don't have will, letters of administration. So the bank will say that please get us one of these documents, and then we will release the funds or the bank locker contents to you.
Okay, this is interesting. I'm getting deep into it. Say there is a bank fixed deposit.
Yeah.
And there is no will. And there are 2 siblings.
Correct.
Let's talk about letters of administration aside. In terms of succession certificate, both of them should get the succession certificate?
So both of them can, but usually there will be one applicant, and what the other one will do is to give an affidavit or a no objection, saying I have no objection to this person getting the succession certificate. Or they can be joint applicants. Again, a succession certificate or a letters of administration doesn't mean you are entitled to those assets. It just means that you can go to court and claim those, but you still have to distribute them to the heirs. So, let's say if there are, I dealt with this situation.
Succession certificate doesn't give you the ownership on the asset.
No, it doesn't give you the ownership of the asset. It is just proving that you are one of the people who is entitled to get those. You can get it, and then you still have to distribute it. So to give you an example, when we were discussing in the beginning, we once had someone, Hindu male, passed away with mother, wife and children, needed letters of administration because nominees weren't appointed and there was no will. So the question is, who will apply for the letters of administration? For 6 months, they could not decide whether the mother should apply, whether the wife should apply, because there was a complete lack of trust. Finally, it was decided that, okay, mother will apply. The wife gave a no objection, and then they did a family settlement on the side where people signed saying, once you collect this money, you will give it to me. Legally, that person had to give it, but still, because there was such lack of trust, it was all documented in a document. Then the mother went to court, got the letters of administration, went to the bank, collected the money, and then distributed as per law.
What is the difference between letter of administration and a succession certificate?
The letters of administration applies to the whole estate if there is no will. Succession certificate applies only to identified. But the court that you have to go will be the same. The process in many of these is similar. It's just that a succession certificate may sometimes be a quicker option because it's only for limited assets.
Letter of administration, so the court will tell how the assets have to be distributed among all the heirs?
Not really. So what in the letters of administration, all that the court is saying is that appointing an administrator for the estate. So when you make a will, you appoint an executor who will administer your estate. But because there is no will, there is nobody to administer it. So the court is just appointing an administrator, saying appointing you as administrator, you collect the assets, you distribute the assets. If there are liabilities, you pay them off, but you don't become the owner. You're just entitled to be sort of the manager of this estate.
Okay. And but who decides who gets what?
That is the law, like we said. So that is, we were talking 2 minutes ago about the law and who gets what, depending on whether how you've been married, who you've been married to, what personal law applies to you, what gender applies to you.
The court will not say anything about that?
The court doesn't. Not in a letters of administration. If there is a dispute, if the family members disagree on what everyone's rights are, then of course they have to go to court so that the court can declare saying, okay, these are the shares that everyone has.
Regarding that letter of administration, as you mentioned, maybe the mother would have gotten the letter of administration, and everyone decided that they will share the property amongst themselves in a good terms, that they've decided they will share the property in a certain manner. But that may not be as per the Indian succession laws or the Hindu laws or whatever, the religious laws. Is that okay?
That is okay. The family members can decide amongst themselves. This is what we would call a family settlement, where they will enter into a document saying that our share might be 1/3, 1/3, 1/3, but we are doing it 2/3, 1/3, or whatever other metric they decide, and that is absolutely fine. They can do that, and it should ideally be documented, written down, signed, and signed by everybody who could have had an interest, so that tomorrow there's nobody to challenge it.
Okay, this is called family settlement?
This is called a family settlement, correct.
Okay, and this has to be again registered or got into court?
No, so per se a family settlement doesn't have to be registered. You don't have to go to court. It can be your internal document. You will, you will read a lot of articles in the newspapers also that so and so disputing they entered into a family settlement. Where you do need a registered document is if there is immovable property involved, and you are sort of relinquishing your rights over that immovable property. So for instance, we were discussing that there are 3 family members who are all entitled to this. Then they say that 2 of them give up their rights. Say we will give, like if there are 2 sons and 1 mother, and the 2 sons decide we will give up the rights in favor of the mother. They can do that, but that has to be in a registered document because it's immovable property.
Now, how long does it take for one to get a probate? What's the time?
It's a difficult question to answer because it also depends on where you are located. Across India, different courts have jurisdiction depending on where the person passed away, etc. Each court and jurisdiction will have a different timeline. Usually, if we were to take Mumbai as an example, it would be typically 9.
Wow. Yeah.
But it could be longer in other places. The reason I say it could be longer in other places is because in Mumbai, for instance, it is because it's compulsory, a lot more probate applications are filed and the whole system is more streamlined. But in other places where it may not be so common, the process is not streamlined, and therefore it could take longer. If in this probate proceeding there is a dispute situation, so the executor applies for probate, but somebody then steps in and say, no, I should also have a share, I'm questioning this will, etc. Then 9 to 12 months could become a lifetime.
Got it. Understood. Okay, so that's about probate, and I don't have to do anything from my side as of now. But it will be all taken care by the executor since the will is written here in
Mumbai. Correct.
Got it. But the family also has to be informed that it takes at least 12 months for all the assets to be transferred in the
so
heirs' names.
Correct. So there are 2 things to point out because I think we will sort of not give the complete picture if we don't do that. One is, of course, probate not only does it take time, but there is also a cost because you have to pay court fees. So depending on the value of the asset, the court fees are determined. But the other thing...
How much would it be?
It's a percentage with a cap of, I think it's around 70 to 75,000 in Mumbai. But different places, it could be different. There are some places where there is no cap at all. It could be 1%, 2%, 3% of the value of the estate. So it really again depends on where people are situated. But one of the things that I want to talk about, because the question could be that does everybody get a probate, even in Mumbai or Calcutta or Chennai? And to be honest, the answer is no. Now, what the law says is that when there is a will, a probate is compulsory for you to be able to claim a right under that will. So the nuance there is that if I am a beneficiary of a will and the will is not probated, tomorrow if there is a question on whether I have inherited that property properly, I will not be able to satisfy that because the will is not probated. But it doesn't mean that the will is invalid. So in reality, not to scare anyone, in reality there will be many people who will not obtain probate. There are crores of people in Mumbai. Not every will is probated when the person passes away. That is a sort of practical call that people will take. There is a legal call that people will take.
Then why is it called mandatory?
It is mandatory because you can establish your right under that will only if it's a probated will. So if there is a question tomorrow in court as to your right to the will, you will not be able to satisfy that yes, you have a right, because the will is not probated. But there will be lots of families who may say that who is going to question? Nobody will question.
And the family could be in nice terms to distribute the wealth the way they wanted it to be.
Exactly. So they may take that call. Where this could be, it's not just a family thing. Say today there is a flat in Mumbai, and the father owned the flat, father passed away, executor decided not to take the will, not to take a probate. Family also said, we don't need probate. Society also said there is a nominee, I will transfer to the nominee then transfer to the family members, all happy. 2 years later, they decided to sell the flat. The buyer came in, the buyer was doing their title report, due diligence on this property. Buyer went to the lawyer, and lawyer said, but they have inherited this without a probated will. So their title to this property is not complete. And so the buyer then asked questions saying, but what if someone challenges it? What if someone challenges the will?
Yeah, I heard this, that in Mumbai, some housing societies, actually buyers will mandate a probate, right?
They could, because the buyer will also want a complete title to their property. If they are buying from you, they don't want to be in a situation where somebody comes up 6 months later and says, no, this will was invalid. Then the buyer will fall into trouble. So ideally they will want to buy from you if you have probate and all of those formalities are complete. This, of course, if somebody passed away 30-40 years ago, then that risk is very limited, because the time to challenge a will would have passed. But if it is more recent, then it is likely that somebody may question the title and not be comfortable that the property has been properly inherited.
What is the time to challenge a will? Time limit?
So it's interesting, because if it's immovable property, so there's no specific timeline. Okay, so that's the one thing. There's no timeline per se. But for immovable property, you have 12 years. Your law of limitation, as it's called, is 12 years. The thing is that the 12 years, if there is a minor, then the minor gets the benefit of that minority. So if I was 1 day old when this happened, then I have 18 years till I become a major plus 12 years. So that's pretty much 30 years that someone's looking at. So if it's, like I said, 30-40 years in the past, then no one cares. But there is always a theoretical risk that some minor may wake up from somewhere and question.
Such cases happen in your experience?
Not really 30-40 years, to be honest.
Okay.
There could be a possibility that somebody wakes up and says, but I didn't know, like for instance, somebody who's living in America has no idea that there was a will and someone has passed, and then discovered it a few years later. This incident I actually heard about last week itself. Child was in a different country. Parents had passed away many years ago. Child had moved to a different country. Grandfather passed away when he was there. He discovered many years later that actually he should have inherited under that will, and then he went to question it. So those things could happen. They're, to some extent, they're theoretical, but the risk does remain.
Understood. And talking about the inheritance, are there any taxes that a legal heir has to pay when he or she inherits the property in India?
No. So in India, there is no estate tax, not anymore. There used to be. There is no inheritance tax either.
Got it. Amongst all this, I just want to bring up how it impacts HUF, because there are so many HUF also that are being registered in India.
Correct.
So how does succession planning and these laws applicable for HUFs?
Yeah. So an HUF is a Hindu undivided family.
Yes, yeah.
And there'll be family members who are, within that. As you know, some years ago, the law was amended so that now sons and daughters have an equal right in that HUF. They're called co-partners. So the interesting thing about an HUF is that the property of that HUF will belong to that HUF. So that doesn't form part of your will. So for instance, if my family has an HUF and they own some shares, then I cannot in my will write what will happen to those shares, because they form part of the HUF's property. But what I can speak about is my interest in that HUF, how that will go.
Got it. in HUF, everyone have an equal share, and I can talk about my share.
Correct.
In that HUF, I have about 1/3 share, and if I passes away, then that 1/3 share has to be distributed among souls.
Correct. But we will typically not quantify it because the HUF share is moving depending on births and deaths. So we will say whatever my share is, it will go XYZ. And usually you want to give it back to someone who is within that HUF, or to say divided amongst all of the co-partners of that HUF. So you don't bring in a third party into the HUF.
Okay. That's not possible also, I guess, right? Because I can also say, I want this to be given to a charity, but the charity cannot become part of the HUF.
So they won't become part of the HUF. That your share would then have to be sort of partitioned and given to them, which gets complicated. You don't want to do that.
Understood. Got it. Now, when we are talking about wills, I think there is another instrument which people use for succession planning is trust. Could you also tell how this trust is different from a will?
So a trust is actually an entirely different concept. A trust is a succession planning tool. It's in the simplest way possible. What a trust is, that I have some property and I have 3 family members. I want that this property should be held for the benefit of my family members by somebody else. And what I am effectively doing is that someone else is the trustee. I am telling the trustee, you take this property, you hold it, and whatever income comes from this property, for instance, you use it for the benefit of the beneficiaries. This effectively tripartite arrangement is a trust.
This I can do when I'm alive itself?
This you can do when you're alive itself. So you can create a trust when you're alive, or you can create a trust under your will after you die. So for instance, now let's take your example. You have a minor son, and you are worried that, after you, that minor son, income will be generated from your properties. You want that your son should be taken care of. You might want to create a trust, and you can do it during your lifetime. You can appoint somebody else to be a trustee and say, look, I'm giving you these assets. You have to hold these assets on trust for my child, and these are the instructions I'm giving you on how this trust is to be administered.
Got it.
So very simply, a trust is really you're putting your trust in someone, saying, I'm giving you my assets, I'm giving you my trust, please ensure that it is used, my property is used for the benefit of the people I am identifying.
Got it. If I have to talk about, use the same example and give the difference between will and trust. In case of will, I'm appointing a guardian for my child and saying that my assets will go to my child, but you are the guardian.
Correct.
So till my child attains 18 years of age, so the assets will be under whose name? A child name with a guardian.
With the guardian who's sort of being able to act on behalf of the child.
Yeah.
Whereas in a trust, the assets are in the name of the trustee. The trustee is the legal owner.
Okay.
And then they have to act as per whatever instructions you're giving them. So guardian has to act as per law. With the trustee, you're giving them instructions. Plus, it's not just till your child becomes major. It can be for whatever age. So a common use of a trust, there are the various different uses. So there are large business families that will use trust to hold shares of the business, etc. But in smaller families, a very common use of a trust is if there is a child who is cognitively disabled for some reason and cannot take care of themselves. Then the parents will create a trust saying if something happens to us, then the child may not be able to take care of himself or herself. So we're creating this trust and appointing someone who has to ensure that for my child's life, they will continue to give that child income and look after them monetarily.
Okay. Which the guardian may not be able to
correct, because
continuously.
Yes, guardianship ends on majority. So when someone becomes of the age of majority, then that guardianship ends. Then that person has to sort of look after themselves. If they have such disabilities that they can't look after themselves, then family members can go to court and get themselves appointed as guardian. But it is in such cases easier if you have a trust and if you give clear instructions to trustees to how they have to use the property and how they have to look after the child monetarily.
Also, I may not be wanting to give the whole estate to my child when that child turns 18. I want
Correct.
I want the child to get the assets when that my son or daughter turns 40 years age,
Correct.
30 years. In that case, trusts can be a better.
Trusts are better options.
So trust is not a person. Trust is a legal entity.
No, actually, so the trust is not a person, it's not an entity per se.
Okay.
Very sort of legally, it's an obligation. So I am creating the trust. You
It's
are
a
the
document.
trustee. So you are the trustee. I am giving you an obligation. I am obliging you that you have to hold my property for the benefit of who I appoint as beneficiaries. It's a very interesting legal distinction. It's not the trust is not a person, it's not an entity. A company, for instance, is a
it's an
legal
entity.
person, is a legal entity.
Yeah.
But a trust is not that. It is just an obligation. So if I give you my phone and say, you are the trustee, keep my phone, I'm going away, I will take it back from you when I'm back. You're effectively sort of almost holding my phone as trustee.
So the trustee can only be an individual.
No, it can be a company as well. So there are, say, for instance, professional trustees. There are trustee companies in India that offer trusteeship as a service.
Oh, okay.
Right. Yeah.
Got it. By the way, in the will, could will or trust, can we mention conditions like my property or my assets will go to this person only if this person takes care of me in my old age?
See, in a will, it doesn't make sense because the will comes into effect after you die. So, like, taking care of you is sort of...
Can I put conditions in that will?
So you could have a conditional bequest, but that condition can't... One is, it has to be a condition that is capable of giving effect to, and it can't be something that is against, sort of public policy. So you can't say that if you murder someone, then you will get that, those kinds of things. But you could have a sort of condition. And this is again a very nuanced sort of this thing in law. What you are saying is that you can do a gift like that. So there is a senior citizens law that came in this country some years ago for exactly this reason, which now says that if there is a senior citizen, who is somebody who's 60 plus, they have a property, they gift that property to the children, they can do it, and in the gift deed say that I am gifting you this property, but you have to look after me. And if you don't look after me, then I can take it back. So
who will ensure that the parents are taken care of or not?
It's if the parents are not taken care of, then they can go to what is the tribunal under the Senior Citizens Act and say that my son or daughter, whoever it is, I have gifted, they're not taking care of me, I want this property back. And then it's the tribunal's job, and you will see this, you will read a number of articles where courts have enforced this right. This has gone to the Supreme Court a few times. But the Supreme Court has also upheld the right of the parents to take back this property if that condition exists in the gift deed, which says that the parents have asked the children that I'm giving you this, you look after my sort of needs, and the children don't do that.
So you tell me, when should I go for a trust and when should I go for a will?
So it's most people get this confused. They think it's an either or question. I don't think it should be that. You should have a will in every circumstance. And then ask yourself, do I need a trust for specific assets? So your will covers your entire estate. It covers all of your assets, PF, etc., everything, right? But for some assets, you might want to think about creating a trust. Now, there are various reasons why you might want to do that. The first is, like we were discussing, that do you have someone who is dependent on you, like a disabled person or, an older person who may not be able to take care of themselves monetarily. So you need to appoint someone else to act as trustee to do it. Do you have a minor child, or do you have a child where you don't want to give them assets and when they turn 18, but you want to give it to them at a later age or tranche it out for them? The other thing is, and a lot of our clients are like that, they have business assets for, so shares in the business, they might want to keep in a trust so that it's, intergenerational, that holding of shares happens so that their business is not fragmented across many generations. So there are different reasons why you might want to create this. There are people, and some of your listeners might be in the US, for instance. So in the US, there are certain taxes, estate taxes, etc. And it is advised that if in India a trust is created, then there might be some benefit there. So if a parent creates a trust for that US child, there might be some benefits. And again, I'm no expert on this, but it is worth checking depending on, if the child is in a different jurisdiction, whether they may have some tax benefits to creating a trust in India. So there are various different reasons why you might want to create a trust. And you might want to create it over your specific assets, not your entire estate.
Got it.
And so your will covers is your sort of wraparound document.
But will should be there.
Correct.
Okay. Correct. Got it. But most of the businesses, business folks or the business families create a trust, I believe, right?
A lot of them do. There are various reasons for that. A lot of business families, if you see listed companies, many listed company promoters have created trusts for their estate and assets.
If we see people like Ambani or Adani, families, they would have created a trust.
So Ambani, I don't know, but I do know that if you pick up the shareholding pattern of an Adani company, you will see a reference to a trust. There are some other companies where also, the shareholding pattern of companies is easily available. You can go to the BSE NSE website, and then if you see promoter holdings, many of them will have a reference to a trust or a trustee holding shares for the trust.
Okay, but for so many people like me who have simple portfolios,
correct, yes,
a will is more than enough.
It's more than enough. People should know that there is a cost to running and maintaining a trust as well, right?
Okay.
The trustee, if you're having somebody who is, a professional, there might be a cost associated, there might be trusteeship fees associated with it. There are filings that have to be done, tax returns to be filed, all of those. So there also has to be a cost benefit analysis. If you are moving real estate into a trust, there is stamp duty as well. So that kind of, you have to weigh the pros and cons of creating a trust. Then are the advantages you're getting sufficient for you to create a trust? And if the answer is yes, then go ahead.
Okay, got it. This is from my personal understanding. You said trust is not a legal entity. So where am I transferring my asset to?
To the trustee. You are essentially transferring your asset to the trustee. The trustee
in the
becomes,
name of trustee, but
correct,
as a trustee.
Yes.
Not as an owner.
In the capacity of a trustee and not as a full owner. The trustee becomes the legal owner, but that legal ownership is qualified. It is not complete ownership. And it is qualified to the extent that they cannot use the income and assets for their own benefit. They have to use it for the benefit of whoever the beneficiary is.
Got it. Now coming to my final segment, where I want to ask about NRIs as well as my assets that are lying outside India. Now, when I talk to you about me investing in a few stocks in a mutual funds and wrote a will about it, I've also invested in a few stocks abroad, maybe China or the US. Now, the will that I have written, can it include the assets that I have in abroad as well?
Theoretically, yes, you can have a will for your worldwide assets written in India, but it is not always recommended. The reason for that is that different countries will have different rules on what a will in their country is like. So in India, like we discussed, the only rules are that you have to be major, sound mind, print it out, sign it, and 2 witnesses have to see you. It's very simple. But say in a China, and I don't know, the rules might be different. They might need something else for that will to be valid. Which if you go to them then with an Indian will later, or your executor goes there with an Indian will later, they may say, sorry, this is not valid as per our country.
And we cannot transfer the assets in the
Correct.
legal heir's name.
Correct. So what is recommended is to examine all the jurisdictions in which you have assets and see whether it makes sense to have separate wills for separate assets. In some places, a probate may be required. In some places, you might need to notarize a will for it to be valid. In India, like we said, there is no notary. So there could be different considerations and requirements. And an Indian will that you create for your worldwide assets may not meet those requirements. So we always suggest that if you have assets elsewhere, consult someone locally to understand what the requirement is. And if it's beneficial, just make separate wills.
we can very well mention in the will, but whether the authorities there will transfer in my legal
Correct.
heir's name is something to be looked
Correct.
into.
Exactly. And the other issue is that maybe you have assets in two countries, both of which probate is required. Then it becomes a problem. Say, for instance, in India, you require a probate, and then you require a probate in another country. If you take 12 months to get probate in India, then you have to go to that other country and get that probate extended, which may take another 6 months. Whereas if you have two separate wills, you can just do that process simultaneously.
Got it. Makes sense. So you're saying that when there are assets spread across different countries, it is better to have different wills for different.
It's definitely something that should be considered, and more often than not, it is recommended.
Got it. And what if I move to abroad in future, because I've written a will now in front of you in Mumbai?
Correct.
What if I move to say suppose US in the future? Will my will be still valid?
The will be valid. The will, there is no issue because this will deal with your India estate. And if you have assets in different jurisdictions,
I may save later. I may save in the US too later.
Correct. So it might be helpful that when you're writing your Indian will, to clarify that this applies to my Indian assets. And then it remains valid wherever you go. You can of course go to the US and write a separate will there and say this applies to my US assets. And you might also want to have different executors, because you might want to have a US executor in the US and an Indian executor in India. So it just becomes easier for them also to manage the estate.
Got it. Now, what if I am not going abroad, but my child might prefer to go abroad in future when he or she turns 18? Then how will the assets be transferred to my child?
That's absolutely, there is no restriction on somebody anywhere in the world from inheriting your estate in India. There are no restrictions. Inheritance is completely sort of available to them.
Even if that person's residence is changed, say suppose my child gets a green card in the US.
Yes.
Even in that case, the transfer will happen in India in that person's name.
That is correct. Of course, there are foreign exchange rules. There is FEMA that applies. So there are restrictions on how many, once they have inherited your estate, how much of it they can take abroad.
Okay.
But that doesn't prevent them from inheriting the estate in the first place.
Understood. Got it. Now I talked about me writing a will and my child inheriting. So what about my parents are in the US, maybe because my brother is in the US and then they moved to the US and settled there. Now, if I have to inherit assets from them, either in the US, assets in the US or the assets in India, how does it work?
In the same way, so they will have an India will and say assume they have a US will, they will appoint the executor under that will. You could be the executor of their India will, for instance, and your brother could be the executor of their US will. The same process applies, where you have to then as executor collect and ensure that everybody who is entitled to those assets gets those assets.
Got it. Yeah, I think that's all from my side, Shaishavi. I think this is a solid information on wills, trusts. It's a lot of information, but I really hope that our listeners will find this very valuable and informational.
Thank you, Satya. I mean, we've had a freewheeling conversation, and I'm glad there's so much that has come up.
Yeah.
And just one last sort of takeaway for everybody is that, as everyone would have realized in this last one hour or so, is that Indian rules are sort of different things apply to different people, and so always bear in mind what your personal situation is, and ensure that if you are trying to get information from various sources, especially online, that it's actually what applies to you and not something that applies to someone else.
Yeah, even if one is writing a will, it is very essential that they have to do nomination for their assets.
Correct.
But for the physical property, nomination is not possible, right?
In Mumbai, for instance, if it's a cooperative society, you can do it because you will have a nominee for your flat.
Okay.
And you have to file the nomination form with the society.
Got it. But in most parts of the...
that's correct.
It's not. Yes. Cool. I'll take that as my last question. Thank you so much for joining us today. And thanks, Shaishavi, once again. It's lovely speaking to you.
Thank you, Satya.
Thanks.